Welcome everyone to our webinar. I'm Glenn Lammy. I am Executive Director and Vice President of Legal Studies for Washington Legal Foundation. We are very pleased that you've chosen to spend an hour of your time with us today, wherever you are. For those of you not familiar with the foundation, we are a nonprofit public interest law and policy center that's been around for 46 years now. We get involved in a pretty wide range of issues that affect the free enterprise system, regulation, and litigation, fighting for what we call business civil liberties, of which property rights and free expression are two things we're going to be talking about today are certainly a part of that. I don't recall when this case first came to my attention back in 2020 when I was holed up during the COVID lockdown, but as a consumer of both whimsical dog toys and Tennessee whiskey, not to mention a strong believer in both property rights and speech rights, I found it really fascinating. So my colleagues here at WLF and I decided that we should publish a blog post on the Ninth Circuit ruling. For those sort of things, we usually look for outside experts. Thankfully, today, one of our speakers, Elizabeth Brannen, accepted our invitation to write. And in April of that year, we posted a piece by her and her firm associate, Janelle James. Liz and Janelle were quite prescient when writing, "It is difficult to dismiss this case as an outlier. As has become obvious from the extensive coverage the case is inspired, as well as the array of amicus briefs filed with the Supreme Court, underlying controversies about a lot more than just dog toy manufacturer poking fun at a stately, hugely successful liquor distiller." To help us prepare interested parties for what I think will be a very interesting oral arguments next Wednesday at the U.S. Supreme Court, we're joined today by Liz Brannen and two legal academics who filed amicus briefs on opposite sides of the Jack Daniels Properties case. Share my screen here real quick for the bios. So Elizabeth Brannen is managing partner of Stris and Maher, one of the nation's preeminent litigation boutiques. Before joining the firm in 2015, she served as director of intellectual property at Barnes & Noble and as corporate counsel in Oracle's litigation group. I also mentioned that she is the managing partner of the firm and is very active in litigation practice, representing clients in intellectual property and other complex business disputes. Joining us also is Adam Mossoff, who's a professor of law at Antonin Scalia School of Law at George Mason University. Teaches a wide range of courses at the law, including, of course, property and patent law, trade secrets, trademark law. He's also a senior fellow at the Hudson Institute, where he's also chair of the Forum for Intellectual Property, and he is visiting intellectual property fellow at the Heritage Foundation. He participated in and the drafting of and signed on to an amicus brief of former judges, senior government officials, and scholars in support of the petitioners in Jack Daniels versus VIP products. And then finally, Andrew Michaels is an assistant professor of law at the University of Houston Law Center, teaches in the areas of intellectual property and statutory regulation, and his scholarship is focused in the areas of patent law and jurisprudence. He clerked for Judge Pauline Newman at the Federal Circuit and was also in private practice as a patent litigator and also a visiting professor of law at George Mason University Law School. And he filed an amicus brief in his own name in support of the respondent in Jack Daniels versus VIP products. For the benefit of our attendees, we are recording this today, and we're also going to be taking questions. If you want to put your question into the Q&A tab, we will get to that question during the end point of the Q&A part of it. So starting off, Liz, get us started with a brief summary of Jack Daniels' claims against VIP products and what happened at the federal trial court level.
Well, this is a very interesting case. VIP Products makes a squeaky dog toy, and they make it in the shape of a Jack Daniels whiskey bottle. It's called Bad Spaniels, and instead of old number 7, they have their squeaky toy bottle labeled with old number 2. Tennessee Sour Mash became On Your Tennessee Carpet. The toy has other kind of humorous elements on it. 43% poo by volume, 100% smelly. But Jack Daniels Properties did not find this funny, and the dispute began with the company sending cease and desist correspondence to VIP Products, which makes the Bad Spaniels toy. VIP Products, though, did not cease and desist voluntarily. They filed a declaratory judgment action in the District of Arizona and ultimately lost after a bench trial. So the district court found in favor of Jack Daniel's Properties counterclaims for trademark and trade dress infringement and dilution by tarnishment. The district court rejected the First Amendment defense that the makers of the Bad Spaniels toy had put forward, and also found, with respect to dilution, that the statutory exemption for a parody did not apply because Bad Spaniels was using the marks for its own good, to identify its own goods in commerce. So in the district court level, Jack Daniel's Properties basically received a sweeping victory.
So then VIP appealed to the Ninth Circuit, which in its opinion didn't completely see eye to eye with the district court. What did the Ninth Circuit hold?
That's right. And this is when, Glenn, thank you for the chance for Janelle and I to write that blog post. I remember this now because the decision came down kind of very early on in COVID. The Ninth Circuit reversed the dilution by tarnishment claim, and they didn't do so, as I recall, on the basis of parity, but on the basis that the non-commercial, the exemption to dilution for a product being non-commercial applied. The product is obviously sold commercially, but the expression was divorced from that. And so the dilution by tarnishment, according to the Ninth Circuit, could not, that couldn't be found as a matter of law. On infringement, the Ninth Circuit actually vacated, and they also vacated the injunction and sent it back down to the district court. They found that the toy is an expressive work entitled to First Amendment protection. And so they remanded for analysis under a test called the Rogers test. Under the Rogers test, which is something that the Second Circuit initially came up with in the context of a motion picture being challenged, not a commercial product. But under the Rogers test, the Trademark Act would only apply if the plaintiff can establish that the use a defendant is making of their mark is either not artistically relevant to the underlying work or explicitly misleads consumers as to the source or the content of the work. So the Ninth Circuit, the ruling didn't completely excuse Bad Spaniels, but sent it back down to the district court to do more work.
So when it got back to the district court applied the Ninth Circuit's ruling for VIP. After that, Jack Daniels once again appealed to the Ninth Circuit, which summarily affirmed, and then Jack Daniels filed a cert petition, which the court accepted back in November. So what questions did the Supreme Court provide to the parties that they wanted answers on when they did grant cert, Liz?
And this was, by the way, the second chance, the second
right.
time. The first time the court did not take the case, but this time. So the way that the petition, Jack Daniel's Properties petition, frames the question, there are two questions that the court is hearing argument on that relates to the humorous use of somebody else's trademark on your own commercial product. One question is, what test applies? Is there a threshold test that the First Amendment requires? You know, the Rogers test or a test like that, when there is a humorous or expressive use? Or is it just that the Lanham Act's traditional likelihood of confusion analysis should apply? And the second question relates to the non-commercial, whether use is non-commercial under the statute and would bar a claim for dilution by tarnishment as a matter of law because it's humorous. So it's going to be very interesting.
So before we get into how the parties address those questions, I think it's important for our viewers to understand what the trademark laws protect. So Adam, the amicus brief that you worked on and signed offers, I think, some excellent thoughts that I'd like to have you share here on the purpose of intellectual property protection.
Oh, thanks, Glenn. So as Glenn mentioned, we submitted an amicus brief in support of Jack Daniels, emphasizing and highlighting a key part of trademark doctrine that is often forgotten, which is also a key part of why we have intellectual property, which is that trademark doctrine specifically is geared to support and reinforce and incentivize the creation of valuable, high quality products and services that are sold to consumers that creates in the law a type of interest that we refer to as goodwill. Goodwill is the value that consumers recognize in the reputation of a company in selling a product or service. Goodwill is oftentimes valued at much higher levels by orders of magnitude than the actual physical assets of a particular company. And a good example of this is Apple Computer. That little apple with a bite out of it is represents probably now hundreds of billions, if not trillions of dollars in goodwill, given the mobile revolution, and before that, the personal computer revolution that was wrought by Apple Computer itself and by Steve Jobs. So good, trademark law is intended to incentivize companies to say, look, if you create a valuable product and service, if you invest a tremendous amount of your productive labors in creating a good product and service and selling that to consumers, creating that massively goodwill that is represented by your trademark, whether it's the apple with a bite out of it, whether it's Nike swoosh, whether it's the square bottle with the particular black label that Jack Daniels has, and so on, that will be protected to you as an intellectual property right, as a trademark. And therefore, other people who choose to try to free ride off of it, try to palm off of it, and try to pirate that goodwill, is the terms that were used historically, will be prevented from doing so. And this is intended to both, as I mentioned, incentivize companies to create good products and services, to invest in that, to police their products and services, to ensure the high quality of their products and services, to create that goodwill, which is what drives both the benefit to the producer who reaps the benefits of that, but also to the consumer. And the reason why I said it's often forgotten in trademark law is because the test in trademark law is called likelihood of confusion. So oftentimes courts and commentators focus on the other half of the coin, which is, are consumers being confused and tricked or misled by this product or service that is using without authorization a trademark or a trade secret or trade dress. But the two go hand in hand, and is long recognized that it's both goodwill and protection of consumers that trademark law is supposed to achieve, which is exactly what intellectual property law does more broadly. As James Madison famously said about patents and copyrights, that this is an area where the public interest and private claims of individuals are unified and are the same. So,
thank you, Adam. So on the first question presented, the parties disagree over how a court should assess the question of infringement, and more particularly, how a court should factor in free speech interests into that assessment. So Adam, what is Jack Daniels' positions on those issues in the case?
So Jack Daniels has taken the position that I don't think many were expecting to take, that for them to take this position before the U.S. Supreme Court, that the Rogers test itself is invalid and wrong, and it's asking actually the Supreme Court to throw out the Rogers test. Not because the Jack Daniels doesn't think that that free speech is important. It just believes that the free speech interests can be accommodated in the normal test, the likelihood of confusion test, that courts use when assessing whether trademark infringement has occurred or not. And there's a certain at a minimum, there's a certain superficial plausibility to this argument, right? Because to the extent that someone is engaging in free speech, they're not selling a product or service. They're not, they're not engaging in similar channels of commerce and other types of activities. Typically, when we think of free speech, we think of someone a comedian making jokes about a product or service, commentary about that product or service in terms of quotes in an academic article or something, things that no one would confuse with with the product or service itself, or think that this was authorized by the company that owns that trademark or that trade dress.
Andrew, how about the VIP product side? What is their position on the first question presented in terms of the test that should apply?
Well, so they defend the Ninth Circuit's fairly extreme version of Rogers, which is that an artistic use of a product is not infringing unless it's explicitly misleading. And they argue that this is necessary because litigating a case through likelihood of confusion can be very expensive. And so a clear bright line rule is necessary to prevent artists from being bullied out of what should be protected uses of trademarks. And they also argue that the likelihood of confusion test doesn't really work in cases of parody that well, because, for example, the strength of the mark normally weighs in favor of likelihood of confusion. But in the case of parody, it's sort of the strength of the mark that allows the parody to be recognized, and also the similarity of the mark. So in the case of a parody, you do need to make it somewhat similar so that people realize what you're parodying. And so although that would normally weigh in favor of likelihood of confusion, they argue that basically that the factors are awkward at best in the context of parody.
So the US filed a brief, and the court's granted the Solicitor General some time, the oral argument, which is definitely significant. So Liz, what's the government position on the Rogers test and whether the parodic nature of the Bad Spaniels product is relevant to determining infringement?
Yes, I'm really looking forward to hearing that part of the argument. As I understand the government's position, they're kind of splitting the difference. On the one hand, they agree with Jack Daniels that there's no special threshold test that is in the statute and nothing that the First Amendment requires, and that the Ninth Circuit got it wrong to the extent they felt that the First Amendment sort of demanded a special analysis that would happen before the likelihood of confusion analysis. But on the other hand, they don't go as far as I think Jack Daniels Properties does in believing that the humorous nature is completely irrelevant. I think the government would say, just as in the context of copyright fair use, where parody does have a sort of special place, and courts do know that when you're applying the same test, you apply it perhaps in a, I don't want to say in a different way, but with a different emphasis. It's sort of, as the government has it, at least I think this is what we'll hear more of an argument, you apply the same traditional factors, but in the run-of-the-mill cases, parody will generally not cause confusion, is what I understand them to be saying.
So the amicus briefs on both sides have varying opinions on whether the court should adopt and apply the Rogers test. In your brief, though, Andrew, you discussed how even the Second Circuit itself has walked back from the test as originally designed. Have other circuits followed, and where does the Ninth Circuit land vis-a-vis those other circuits in its Jack Daniels decision?
Well, so what the Second Circuit does is basically they require, when there's free expression at issue, they require a particularly compelling case for confusion, like a more compelling case than normal for likelihood of confusion, to outweigh the free expression interests on the other side. So basically, it's a more flexible balancing test, which I think is more coherent because that's really what you're balancing, is likelihood of confusion versus the free expression interest. It doesn't really have to do with explicit versus implicit. And so only a couple other circuits follow the explicitly misleading formulation that the Ninth Circuit uses. There's a couple that follow sort of the more flexible intermediate approach that the Second Circuit uses. And then about half the circuits have decided, have not adopted the Rogers test at all, either because they just haven't passed on the issue or because they've decided that likelihood of confusion itself provides sufficient protection for the First Amendment.
So some have argued that because of the context in which the Rogers case was decided, it shouldn't be applied at all. Can you talk a little bit about how the Rogers case came about?
Yeah, I mean, so the Rogers case was a film called Ginger and Fred, which was about two dancers in, it's a Federico Fellini film. It's about two dancers in a small town in Italy who developed a reputation in the town as really good dancers, and people started calling them Ginger and Fred after Ginger Rogers and Fred Astaire. And so then Ginger Rogers sued, arguing that people would be confused into thinking that she had endorsed the film or that the film was about her, when in fact it wasn't about her at all. It didn't have anything to do with her. And there was some survey evidence that indicated that I think like 38% of people might have thought she had something to do with the film based on the title alone. And so there is some potential for confusion there, but still the Second Circuit thought that the First Amendment interest in being able to choose a title for your movie outweighed that potential for confusion, and so they found no infringement there. And they did limit that. I mean, so basically what they said is you balance the free expression interest against the likelihood of confusion. And then they said, in the context of an allegedly infringing title using a celebrity name, that balance normally will not support infringement unless there's explicit misleadingness, basically. And so it was limited to that very specific context. The Ninth Circuit basically took that language and ran with it and basically applied it across the board, which I don't think is appropriate. But so I argue more for the Second Circuit's more flexible approach of just adding a thumb on the scale to outweigh, requiring a more compelling case for confusion to outweigh the free expression interest.
Was it relevant that Ginger Rogers' claim wasn't even a trademark claim? It was a common law. I forget what the
yeah. So I saw that argument was made in the government's brief. I don't think so. It was under 43A of the Lanham Act, and even, I mean, the Second Circuit as well has clearly extended that general balancing framework to clear trademark cases. So I wouldn't put too much on the fact that it involved right of publicity as well as trademark infringement.
Thank you. So the parties' briefs and the amicus briefs differ over what artistic expression even means, and whether Bad Spaniels, the product itself, should be viewed as a utilitarian product or expression. So you had a brief like the Motion Picture Association, which urges application of the Rogers test for artistic works like movies, but not for consumer products. Andrew's brief urges against that kind of a distinction. Liz, do you expect the justices to consider the allegedly infringing item as expression or a product, and will that matter to them in their analysis on the first question?
It's a great question, Glenn. It's very hard to draw lines here. I can get my brain wrapped up in knots when I try to start thinking about how one might distinguish what's pure expression or quintessential expression. Sure, a movie, but there's a lot of money made by selling movies, and people sell newspapers as well. So it's actually very hard to come up with a way, in my mind at least, to divorce expression. It can't be that you don't get any protection for expression if there's anything being sold happening along with the expression. That just doesn't work, because even movies and newspapers are sold. So I am always hesitant to predict what the court will do. I've learned my lesson on that one. But I do think that if they try to decide the case very narrowly, here there was a finding, and it was after a bench trial, and it makes sense to me that the Bad Spaniels and the other marks on this product were source identifying. They weren't just expression, but they were expression being used in a trademark way, in a trademark or trade dress sense. And so that would be one way that the court might say, well, I'm going to tell you about that, and I'm not going to tell you what happens in the next Ginger and Fred, because maybe they'll try to decide narrowly, and sometimes we see that. Other times, the court is more inclined to speak to other, scenarios, and we may learn a little bit more. But at that point, I would have to hear from Adam and Andrew about what they think might, what lines they think might be drawn, because it's just very hard to draw them here, at least for me.
So Adam, you're and your co-signer's amicus brief, what sort of take does it have on the likelihood of confusion assessment, and how strongly speech should factor in if the infringing item is seen to be expressive or considered to be expressive?
Yeah, it's a great question. And like Elizabeth, I have long stopped trying to predict how the Supreme Court's going to rule or how they're going to decide a case. I after I've been burned so many times, it's just not a good thing to go, not a good place to go for me anymore. But our brief does not take a specific position on the doctrine as such. Whether the Rogers test should be used, whether just likelihood of confusion or some modified version of the Rogers test. Because the position of our brief is that the Rogers test, at least as formulated by the Ninth Circuit and arguably by the Second Circuit, is too much of a blunt instrument. I mean, so much now of the trademark disputes arise, so much of the trademark disputes that arise at where a defendant invokes some type of free speech defense, which by the way is almost every time now. The fight occurs over whether Rogers applies or not because it excludes any discussion, as referenced earlier by Andrew, of kind of the broader kind of concerns that trademark takes into account, like to what extent is someone actually pirating someone's goodwill or not. I mean, I totally understand in a certain sense the concerns of like the Motion Picture Association, because but I disagree with Elizabeth, right? That a movie is a movie, and it's fairly understandable. And in fact, that look, me, or someone drinking, the James Bond drinking, Cherry Coke Zero, or villain drinking Cherry Coke Zero. No one's going to come away from that movie thinking, oh, Cherry Coke Zero endorses Spectre, endorses, or endorses, British spies. Or no one thinks that Andrew drinking drinking his Starbucks is, people think, oh, Starbucks endorses everything that Andrew now says as a professor. So I think, that's fairly easy. And in fact, I think that, the Rogers test kind of arose from that exact situation. Even though, the focus was on the title, the confusion about the title, the reality is that anyone who went to see that movie, no one came away from that movie thinking, oh my God, that was totally endorsed by Ginger Rogers. I mean, no one did. And so that's the type, but by the way, those are the types of inquiries that the likelihood of confusion test asks you to make. It says, what's the full customer context of the experience of the mark? Is it being used as a mark? What's the channels of commerce? Things of that sort. None of that happens in the application of the Rogers test as this now being applied. So really what we argued for in our amicus brief is trademark law is not just about making sure we don't infringe free speech and not just about ensuring that consumers are protected. It is about protecting this valuable goodwill that has been created. And Jack Daniels is certainly one of the classic examples of kind of Americana. It's known around the world. And they, and Jack Daniels had significant evidence of likelihood of confusion. I think their survey found almost 1/3 confusion, which is, massively high for in standard trademark infringement cases, where I think you only need 8 to 10% on average for on that issue. And they do license dog products. So there, it's totally understandable as you start to fill out the full context of which you're supposed to assess in a trademark infringement case that, yeah, infringement is happening here. Also, by the way, VIP, this is not the first time VIP has gotten in trouble under trademark law, because they do this all the time. And they got sued by Anheuser-Busch for doing a spoof dog toy product on Budweiser, and they were found liable for infringing Anheuser-Busch's trademarks in Budweiser in 2008, and probably in a jurisdiction that doesn't have the Rogers test, because then they reach the likelihood of confusion assessment issue. So, our position is we really do think this is an infringement. This is, someone pirating someone's goodwill. They're using parody as their kind of as their cover for selling a product that uses someone else's mark. And that they should be found liable, but and therefore the court needs to address whatever test, whether it's likelihood of confusion, whether it's some modified version of Rogers, to make sure that they're accounting for those types of relevant facts in assessing these cases.
Andrew, your brief did something interesting, which I don't think any other brief did. You went into the question of whether or not the court or the jury should make the decision on likelihood of confusion. Can you explain why it's important for the court to address that issue?
Yeah, well, I just want to say, under the Second Circuit's version, you definitely do get into likelihood of confusion. You just need a particularly compelling case for it to outweigh the free expression interest, and that's what I'm arguing for. So, the argument for the Ninth Circuit's test, as I mentioned, was that you need a clear rule because it's too expensive to litigate to trial, and then artists will get bullied out of what should be permissible uses of trademarks just because of the cost of litigation. So, but if it's a question of law, then it's more possible to decide it on a motion to dismiss or early summary judgment. And so that at least mitigates, I think, the concern about the litigation costs. And I think it properly is a question of law. Ultimately, it's a multi-factor test. Yes, maybe some of the factors, such as evidence about actual confusion, are issues of fact, but some of them are legal questions, such as the strength of the mark, and the ultimate balancing of them, I think, is a clear legal question. So I think it's a question of law based on underlying facts, like, say, obviousness in patent law or fair use and copyright. And so the Second Circuit does treat it that way, but most circuits actually treat it, including the Ninth Circuit, treat it as a question of fact, which I think is incorrect. So I think in this case, although I think the Ninth Circuit's approach was incorrect, I think the court could decide that there's no likelihood of confusion here as a matter of law, because it's a pretty clear parody, and or at least they could decide that there's not a sufficiently compelling case for confusion to outweigh the parodic free expression interests, which I think maybe are not as great as in the case of like a parodic movie, but I think there's still some free expression interest there. And so I agree with Elizabeth that it's it's too hard to draw a binary separation between ordinary commercial products and free expression. But the advantage of the Second Circuit's flexible approach is that you don't have to do that. You can give some free expression weight to a parodic dog toy, although maybe not as much as you would give to a parodic film.
Liz, as a patent, trademark, copyright litigator, how do you think that if the court does determine it's a question of law, how is that going to affect litigation in terms of favoring either plaintiffs or defendants in those kinds of situations?
It's a great question. My practical answer is it may not affect it very much. I'm interested to see how much in the briefs, I'm sensitive to the fact that if you start from the premise that speech is good, and that usually the answer for upsetting speech is more speech, and that you have to have a really good reason, like, say, protecting consumers from being misled, right? Buying a product thinking it's baby food, but it's poison. If you start from that premise, then and the premise that litigation is very expensive and we should make it easier for the poets and artists to get out, then you might think that making it a question of law would make it easier for courts to just sort of rule early on, kind of the way the Ninth Circuit did in this case. But I feel like even when the Ninth Circuit decision came down, my thought at the time was, everybody, poke fun with caution. Clients frequently come to me and say, can I do this? And my answer is, well, like, how much do you want to pay me? Right? Because whether the judge is deciding it or the jury is deciding it, and whether it's traditional likelihood of confusion or there's an extra Rogers test, if you're doing something that someone has spent a lot of money developing a brand does not like, you can expect a cease and desist letter at minimum. And I think it's actually very interesting here that that's how it started. It didn't start with a lawsuit. This could have gone away if they got that letter and stopped making the toy. But if you come at it from the premise that, well, look, people spend billions of dollars in this country to develop their brands, and we need to make sure they can reliably do that. And if they don't want their high quality whiskey associated with poop, like you've got to have an answer for that. I'm just not even sure whether you would favor the judge or the jury in any particular instance. Probably the judge, but again, I'm not sure which way it would cut. It feels to me like in patent law, you want, the ultimate question to be a question of law when you want to be able to get summary judgment. So that's what I assume it would happen, would be the trend here, but I'm not even sure if we'd have really a way to tell, because it's hard to know who the jury is going to like and side with, and it's hard to know how a given judge is going to see something. A given judge could have First Amendment sensibilities that outweigh, right, the commercial investment in any given case, and you really might not know until you actually went before them and got the answer. And who wants to be the first person to take that test run, right?
Right.
I don't know.
Thanks. So let's move on to the second question the court poses, which is whether Bad Spaniels' use of Jack Daniels' mark was "quote unquote" non-commercial as that term was used in the Trademark Dilution Revision Act. Adam, what's Jack Daniels' position on that question?
Well, it's clearly commercial. They're selling I mean, this is every aspect of the product is its parodied use of Jack Daniels' famous trademarks and trade dress. I mean, I think it's a really easy question to get at, and this is kind of the Jack Daniels approach to this, right? Is that strip away every aspect of our trademark and trade dress that they're using, the shape of our bottle, the look and font of our label, and things of that sort, our particular logos, our specific names, things of that sort, and there's nothing left of the toy. And I think that's the key part of this. This is why I disagree with Andrew that, oh, this is parody, so this is clearly should be exempted. I mean, if that's the case, if this becomes clearly should be exempted as parody, there's nothing left of trademark protection for any famous brand, because then all someone has to do is take a trademark and dress it up in some humorous way, whether it's cereal, whether it's a car, or whether it's something else, and now that's parody. Call it parody. Oh, we're just making fun of it. Yeah, Gucci would never have a cheap motorcycle or a cheap car, so therefore this is parody, and there's nothing left anymore of that trademark protection, and that turns trademark law on its head. It's exactly the point we made in our brief. If the point of trademark law is you invest the time, money, and resources to create valuable goodwill, and you sustain that goodwill through your active policing and nurturing of that goodwill over many time, which is what Jack Daniels has done. It's a trademark that's about 150 years old, then you should be protected in it. This is classic, and the earlier course used it. This is, the fruits of your productive labor should be secured to you like any other property owner. And that's classic justification for what we see in patent law and in trademark law and in real property, right? So I don't see, to me, I look at this and be like, yeah, it's parody, but it's a company that's exploiting parody to sell a commercial product that it's free rides off of someone else's mark. And that's the case where parody should not count.
Andrew, how did VIP respond to that?
So I don't think they're free riding off of Jack Daniels' reputation at all. Jack Daniels doesn't have any reputation in the dog toy space. No one buying this toy thinks they're buying whiskey. It's not even a Jack Daniels dog toy. It's a Bad Spaniels dog toy with a dog on it, with all sorts of jokes embedded on the dog toy. I mean, there's nothing left of trademark law. I mean, if they created a cheap, bad version of whiskey and called it Jack Daniels, then they would be free riding off of Jack Daniels' reputation in the whiskey space and harming their goodwill in that space, and that would be protected. That's exactly what trademark law is meant to protect. In this case, I don't think they're harming Jack Daniels' reputation at all. And I think they do have a free expression First Amendment interest in what they're doing. I think parody is an important interest that's protected by the First Amendment. And I think to the extent there's any minimal confusion here, which I don't really think there is very much, I think it's outweighed by the important First Amendment interest in protecting parody.
Well, I mean, that's a nice statement, Andrew, but you actually had a factual error, which is something I pointed out earlier. They license in pet supplies and pet products.
Well,
yeah,
they licensed a few things in the dog toy space to help sell their whiskey, which they only sell at their factory where they produce the Jack Daniels. They don't have a serious presence in the dog toy space. It's something they're using to sell their whiskey. That was in the Kellogg case. They dismissed that for the exact same reason. Kellogg golf ball that they were using to sell their cereal, but they didn't have a serious presence in the golf space.
Okay, well, I appreciate that, Andrew, but last time I looked at trademark law, it didn't require serious presence as a fundamental requirement for the protection of a trademark or the.
Well, it does require likelihood of confusion.
Andrew, can I finish, please, for a moment? Thank you. it doesn't require a serious presence. The factors are like similar channels of commerce, customer confusion, how much of the mark is actually used, and things of that sort. Now, you can reframe that as serious presence, but that's not what it means. And in fact, trademark law often secures people in the use of their marks and in the protection of their goodwill in product areas that they haven't even gone into yet. It's a very famous case, Virgin, where Virgin, stopped someone from selling Virgin cell phones before they're, because they were expecting to go into the selling of that of that type of product and service. So we don't narrowly frame, and trademark law has never narrowly framed trademarks. I mean, well, they did hundreds of years ago, but not now, to just literally only the particular product line that they have. In the same way that copyright protects derivative works, trademark protects extension of goodwill and use of those trademarks in other areas that can lead that involve people pirating off of that goodwill and those trademarks.
Okay, so if you want to go through the factors, we could talk about similarity to the products. We have dog toys versus whiskey. Those are very different products, which alone, in many cases, is enough to find no likelihood of confusion. We have pretty serious differences in the marks. It's not Jack Daniel's dog toy. It's Bad Spaniel's dog toy with a picture of a dog and jokes on the bottle. And the intent here was clearly to parody. It was not to confuse people into thinking that this toy is made by Jack Daniel's. So I think it was clear legal error for the district court to find that that factor weighed in favor of confusion. Other courts have said that an intent to parody is not an intent to confuse the public. A parody needs to make clear that it is not the original and is in fact making fun of the original, which I think is exactly what this dog toy does.
Well, it's nice that you've accepted at face value their claim that it's parody. I state that that's a strategic use of parody to cover up a business model that pirates and commercial and profits off of someone else's mark, just as the court found in the Anheuser-Busch case, and they would find in other cases. I mean, if they produced a breakfast cereal and called it, Jack Daniel's, Fruity Loops O's, you would say, oh, well, that's clearly a parody because Jack Daniel's doesn't sell breakfast cereal and things of that sort. But the fact, and and they put something that looked like the bottle on it and everything, But again, I think that no one would think, oh yeah, we have to accept on face value that that's parody. Just because a company says this is parody doesn't make it so. And I think this is an interesting distinction: is that if we had a comedian or someone making this argument and they got sued by Jack Daniel's, I think your assertion that this is obvious would clearly apply. Yeah, but the fact is you have a company selling a product. There's nothing to the product if you take away all of Jack Daniel's marks and goodwill and trade dress, and therefore this is not. I don't think this is as obvious at all. I think this is clearly a case of a company having read Hot Diggity Dog and the Louis Vuitton case and then saying, here's a way we can make more money now off of other people's marks.
Andrew, last word before we move on to Liz.
To show the picture of it again, I think it's pretty clear it's a parody. I mean, I agree, you don't just accept at face value someone says it's a parody, but this is pretty clearly a parody if you look at the picture of the dog.
So one of the things that VIP asks for in its brief is to hold the Dilution Act unconstitutional as a restriction on speech. Do you think there's any chance that the court is gonna go that far?
It feels unlikely, although I must say when you read the briefs in favor of the argument, it strikes me as sort of, where do you start from? It feels implausible because we've had that statute for a long time, and the First Amendment's been around for a long time, but actually trademark protection is earlier even than that, although not the specifics of what we have today. I think it does seem unlikely that they would go that far, particularly given, I think it boils down to, first of all, past precedent. There is some there's a San Francisco arts case that they just may say this question's been settled for long enough where we're not going to touch it. But I do think it's very interesting if you try to think about, well, what justifies the dilution statute? Are there findings by Congress of an interest that would be compelling enough to limit speech when there is no specific finding of likelihood of confusion? And to me, it all hinges on, well, which side of the line do you fall on? Do you fall on the line that maybe Andrew might find more compelling, where it's like speech is important and we have to have a very good reason to constrain expression even when it's done in connection with products that are being offered for sale? Or do you fall on the line where I suspect Adam might, the line that he might be more sympathetic to, where if people are going to invest and we want to encourage them to invest a lot of money in developing brands, is it important to make sure that they can control what's happening to their brand? Particularly, I mean, this example isn't as bad as some of the examples from the briefing, but you get into the pornography examples, the Debbie Does Dallas. Do you want your brand to be able to be associated with that with no recourse? A court that finds those interests compelling, I think, the business interests will be very hesitant to declare that statute unconstitutional.
So moving on to sort of what to expect from the oral argument, Adam, are there specific questions that you're looking for from the justices? Are there certain justices that you think should be very interesting to follow as this argument goes on? Which one's going to get the most laughs in their questions?
Who's going to be striving for humor and parody points in the
Right.
oral? That's a great. Well, if Justice Breyer was still on the court, of course, I would say Justice Breyer, he was always the one who was most interested in intellectual property, and as was Justice Ginsburg as well. So if those two were still on the court, I'd say look for Breyer and Ginsburg, because those are going to be your lodestars, because they had such an influence, I think, over the court, because they were cared about these issues very deeply, personally, professionally. They developed a jurisprudence over these issues. Now that they've both stepped down from the court, are no longer on the court, it's interesting. We're kind of in this phase where it's a little unclear, who's going to become kind of the new kind of justice that is most interested in these issues. Justice Thomas has been very prominent in patent law lately, and by lately I mean the past 10 or 15 years. But I don't know if he has shown or expressed similar interests in trademark. He dissented in Google v. Oracle, and but his positions in patent law have been much more in favor of third-party interests and viewpoints and positions that look to eliminate or restrict patent rights. So it's unclear whether he'll go kind of the patent route and trademark law, or the copyright route and trademark law, or and be more protective. So it's going to be a very interesting oral argument to watch, I think, because not just of there's going to be clearly some jokes and things of that sort that will be made, but that we're going to start seeing various justices eventually developing their jurisprudence on intellectual property issues, and we're going to maybe perhaps start to see after the next couple of years some people really coming out of who's going to be the next Breyer and Ginsburg on the court.
Andrew, any thoughts on what to watch for?
Well, I guess my sense is that the Supreme Court is pretty in favor of First Amendment, free speech protection in general, which I would say is a good thing. And I think it's a very important thing at this time. And so, I'm hoping that they will adopt at least, make clear that the First Amendment does protect parity, and that's, an important value, and adopt like some version of the Rogers test at least.
Elizabeth, any thoughts? I guess that the one question I would have is that what's interesting about this case is it's much more relatable than your Google versus Oracle type case, and even the Gonzalez versus Google case, where someone quipped that you didn't have the 9 leading voices on tech sitting up here asking questions. Will the relatability of the issues in the case and the factual situation make a difference in the kind of questioning that we're going to see? Thank you, Elizabeth. You're on mute.
Oh,
I think so. I mean, yeah, I mean, like it is hard. It is kind of hard to listen to the patent arguments sometimes because, or Google versus Oracle, where they're trying to talk about code, or the recent one where they're talking about the internet. So yeah, I think that we may get like better questions in this case.
Elizabeth, any thoughts on the questioning?
I think it could be hard because it could there are just so many examples, if you have time to craft one, that could really hit home. This is a case where my 8-year-old can grasp, like, oh, mom, I hope you're on the side of the people who make the dog toy. And then you say, oh, but what if you got to do this with your YouTube channel, and then somebody associated that with poop? Would you like that? There is a basic level that you can relate to this case on, that is harder to do in a Google versus Oracle or a highly technical, hyper technical type setting. So I think we could hear some real zingers, some very hard hypotheticals. I would miss the Breyer hypothetical.
Any chance any of the justices are going to bring the connect the dots assignments that they were given by one of the amicus briefs on the VIP side, and have them hold them up as they're filled out and say, is this expression or is this not expression?
Yeah. In fact, I think I even saw the VIP filed a motion to actually provide their dog toy to the justices, which by the way, it was a bit of a head scratcher, because that's not what you're supposed to do in trademark cases, is, because the point is that of the likelihood of confusion, you're supposed to assess it in its commercial context. And so if a judge is actually in the courtroom, or especially an appellate courtroom, kind of looking at the product and trying to assess whether this is, an infringement or not, or whether this falls within one of the trademark defenses, that's kind of a deep fundamental violation of what trademark is supposed to be doing, which is to be assessing the mark in its context and in the context of the goodwill that's been established with consumers.
One of our online attendees was asking about whether, in terms of protecting the First Amendment, is there a distinction between dilution by tarnishment and dilution by versus blurring? Is that something that you think the justices will take a look at, or could you explain that, whether there's a distinction between blurring and dilution? I open that up to anybody who'd like to answer.
I mean, I did see some persuasive arguments in the briefs that dilution by tarnishment is unconstitutional, but I don't think they need to reach that, because I think if there is the fair use exception, which includes parody, which I think this falls squarely into, so I don't think they need to reach that. As far as dilution by blurring, I don't think that's at issue here, but normally I would think that tends to be in a situation where you're using exactly the same mark for a very different product. So if it were actually a Jack Daniel's dog toy, I think there might be a stronger case for dilution by blurring there, but I didn't see that discussed very much in the briefs.
Yeah.
Like a Jack Daniel's dog toy that wasn't licensed by Jack Daniel's.
Or that wasn't, right, and that wasn't Bad Spaniels, it was actually
right.
Jack Daniel's.
Said Jack Daniel's. Okay.
Yeah. I get some of the cognitive dissonance that the very dilution statute causes with trademark lawyers and scholars, because the idea is that, okay, this isn't an instance where there's confusion by consumers. So in what sense does it implicate the goodwill or not of a company? Because the two usually go hand in hand in the way people think about this thing, these issues, and it makes sense. But at the same time, I don't think it's as obvious or a strong argument that dilution by tarnishment is necessarily unconstitutional, getting to the issues that Elizabeth mentioned earlier, which is that, with really famous marks, you get a problem that there's no longer confusion. So if there's, so if someone wants to do Disney pornography or Jack Daniel's pornography or something, no one's going to all be like, oh my gosh, Disney's gone into pornography. I no longer really want to go to Disney anymore because they're now supporting pornography. So no one's confused by that, but it does undermine and pollute and tarnish the strength of their mark as established by the goodwill that they have created. And so, it's a difficult issue to get at, especially in the context of trademark law, but I totally understand it. And I think it's legitimate. And it goes to exactly this issue. I think it underlies this issue that we're addressing in this case, which is you have very famous marks. And with the fame of a mark, which is the result of a company and a commercial enterprise engaging in incredibly productive labors over a very long period of time, there are people who then want to make fun of it because it's famous, because the parody only works if you're making fun of something everyone knows. Or use it in contexts where the mark owner would disagree with it, like pornography or something of that sort, where there's no confusion. But the mark owners, I think, in terms of protecting their goodwill, have a legitimate claim in those contexts. And I think that that needs to be considered.
With respect to the question about whether the court will address blurring versus tarnishment, I don't know. I think in a case where that was more extensively briefed, that might make some sort of a difference, but really I think we can hope and expect to see the discussion here maybe clarify what is meant by non-commercial or commercial in this context. In the context of free speech, commercial speech is very narrow. It has to propose a commercial transaction. But the non-commercial exemption may not extend to speech that is commercial in the sense that you're using it in a trademark way to try to brand your Bad Spaniels product. I think we'll see them talking more about, in this case, what does it mean to be commercial or non-commercial? Because remember, the Ninth Circuit found that the expressive aspects of the Bad Spaniels toy were non-commercial. And that seems strange unless you have in the back of your mind the First Amendment commercial speech doctrine where commercial is very narrow, but it may be broader in the statute.
Andrew, Adam, any final thoughts?
Andrew, I'm sure you've got to say something that disagrees with what I had said earlier, please.
Well, I just,
Hit me hard.
on what we were just talking about, I guess I'm not sure about the non-commercial exception, but I think that the fair use exception much more clearly applies here. So I think that would be the easiest way for them to dispose of the dilution claim.
Well, we are just about out of time, so I want to thank Adam, Liz, Andrew for joining us today and illuminating some of the issues that the justices will be talking about. And clearly the level of discussion here shows that this is more than just a case about a dog toy and Jack Daniels. And my hope is that more people will listen to this argument because it is available easily to listen to online. And I think there's a lot to be learned from what comes out of this case, both from ownership of property and creation of products, ownership of marks, and free speech as well. And again, thanks everyone for tuning in. We both all have a good rest of the day.
Thank you, Glenn. Thank you, Elizabeth. Thank you, Andrew. It's really
Thank
fun.
you all.